Good morning, ladies and gentlemen. This is the 6th day of the L2 construction series. We have Chelsea Pollard with us today. We are lucky to have her from the Asian International Arbitration Centre, or AIAC. Not only with the MCO being in place at the moment, where the physical office of AIAC is closed, at this point in time, unfortunately, we also do not have a director as yet after the passing of Mr. Vinaya Pradhan. Now, I'm sure that a lot of people who are involved in arbitration or adjudication who have a lot of questions for AIAC. And Chelsea, being with us today, she will be very willingly answer all your questions, all right? And she's ready as well. But before that, let us begin with some of the preliminary questions for Chelsea, and followed by questions from the floor. So everybody here who actually has any questions that you would like to ask of Chelsea, being the representative today of AIAC, please put it down on the chat room. And at the end of our questioning, we will go through those questions and we will ask those questions, put those questions to Chelsea for our answers. It also depends on how much time that will be left off after the interview by Hong Kit and myself. And we will pose as many questions as possible to Chelsea. Now, before we commence, perhaps Chelsea, would you like to introduce yourself to the audience briefly?
Sure. So as some of you and many of you may know, I'm one of the international case counsels at the AIAC. Originally, I'm from California. So joined the AIAC back in September of 2018. Ended up in Malaysia following I did the pre-moot competition, which I think some of you have acted as arbitrators for. So I did that back in 2018, in March 2018, and then joined in September 2018. I've been here ever since, and the food and people like Hong Kit and Wai Loon have kept me around.
Okay, are you comfortable now? I mean, in Malaysia, are you getting used to the life and the people in Malaysia? Are you still thinking of going back to California after this?
I mean, right now I can't really go anywhere, but I mean, I really love it here in Malaysia. I love, like I said, I love the food. I love the people. I think the humidity is the only thing that I don't enjoy, but I don't think I'll ever get used to that. So just have learned to like AC a lot more.
All right. I think you'll be here for some time at the very least. So let's go to the questions then. I'm sure, you know, these questions that will be asked of you would also be the questions that the audience would like to know as well. So I would like to ask you as well. So my first question is this. The physical office of AIAC is closed at the moment, right? But I'm told that the AIAC team is still working as usual. And you know, how does that work? If any party to an adjudication or would like to pursue an adjudication or arbitration, how are they going to contact AIAC?
Yeah, so all of the AIAC case counsel and staff are all working remotely from home. So if you have an ongoing matter, the best person to contact is the case counsel that is in charge of the matter. You should already have their email address and hand phone number, so you can send them a WhatsApp or send them an email. For any inquiries you have that aren't related to an ongoing matter, we have our respective email addresses for each department. So we have adjudication@aiac.world, arbitration@aiac.world, mediation, also DNDR. Also, if you just have a general inquiry, we have a catch-all, which is the inquiry@aiac.world. So if you're not sure which one it falls into, you can always email that and it will get directed to the respective person that can answer the question.
No, Chelsea, you mentioned about WhatsApp of the special or specific personnel in AIAC who are responsible in various respective departments. And you have also mentioned about various links and a specific email address as well, where the any person who has any inquiries would be able to contact AIC personnel through or via those channels. May I know how, if I'm, I don't know, I cannot go to the, even if I go to the physical office is closed, how am I going to get this information about the various channels that you have just mentioned?
So if you go on our website, there is a news and announcements tab, and in the announcements tab, we mentioned how the AIC is operating during the MCO. It has all of the various emails addresses in there that you can contact, and I'll tell you which email addresses for each department.
I see. All right. So they just need to log on to the AIAC website. They will be able to get all this information, right?
Correct.
So yeah, what you are saying is that even though the physical office of AIAC is not open at the moment, the people in AIAC are actually virtually working, and it is really, in a way, business as usual for AIAC. Am I correct? Of course, all of you are working with certain constraints as well. Now, I would like to know that, when, let's say, for example, it is an adjudication matter. And as you know, in CIPA, the statute itself, the provisions are very strict with regards to timeline. And many times, these timelines are stated in the form of working days. Now, what you are saying now is that AIAC, even though the office is closed, but it's business as usual. The people there are still working, are attending to inquiries. Now, let's say there are certain documents that I need to serve on AIAC, and the office is actually closed at the moment. The first thing that comes to my mind is that because I'm prevented to carry on with my obligations under the provisions provided under the Act or the AIAC rules, how do you actually view about the calculation of these working days? Are they going to be still calculated as usual, or are they going to exclude the MCO days from the calculation insofar as the administrative center is concerned?
So as far as we are concerned, the days under CIPA, so the working days, are not affected by the MCO, because technically all offices are working from home or working remotely, and there was nothing from the government that stipulated these days should be considered as holiday days or weekend days. So our understanding is that it's the MCO days are working days. So in terms of things that need to be served, it really depends on whether you have an ongoing matter or a new matter. For the ongoing matters, it's a bit easier because you can request from the parties and either the adjudicator or the arbitrator if they will accept service by way of email, or you can ask for extensions of time. For new matters, however, for example, the Form 3A that needs to be served on the AIC, it has to be served pursuant to Section 38. So that would mean it needs to be physically served on the AIAC, and currently, because we're not open, it can't be served. So we would say that those need to wait until after, so the new matters would need to wait until after the MCO is lifted to be able to register the adjudication matters.
I see. So what you're saying is that insofar as the administrative part of it, if there will be certain constraints that might cause or prevent the commencement of adjudication proceedings. Now, let's say, for example, I have a claim, right? Right after now, there is a claim that is due for payment. Prior to the implementation of the MCO, I have already served a payment claim. Now, the only thing is that I have not initiated the proceedings at the moment. And you have also mentioned that I cannot actually serve it on physically on AIAC. And furthermore, there is also no director in place at the moment. If I remember correctly, the provisions specifically provide that the service is technically speaking on the director of the AIAC. Correct, Chelsea? So
Correct.
what are the suggestions that you would actually give to these people if they wish to commence adjudication at this juncture?
So our suggestion would be to first wait until the MCO is lifted and also until the new director is appointed, just to make sure that there's no potential procedural objections that the other party may have. The worst thing you want to have is have a procedural objection at a later stage in a case that can throw your case out and end up costing you more money. So if you just wait until the new director as well as the MCO is lifted, then we can have, can go smoothly. Same with arbitration as well. Considering arbitration, it also under our rules says the commencement needs to be served on the director. You can still send us via email all of the documents, so that way we can ensure and let you know whether there's anything missing. So that way once the director is appointed, you make sure that you have everything in the commencement ready. So for arbitration, if you want to email us just to make sure that you have all the required documents, you can do that. But the commencement cannot occur until the new director is appointed.
I see. Okay. So what you're saying is that if when it comes to commencement of adjudication and arbitration, I think it would be safer, correct me if I'm wrong, to do so only when the new director is appointed.
Correct.
Yep, all right. So let's say, but that is for a situation whereby a party wishes to commence adjudication or arbitration. Now, what about ongoing? How do you deal with ongoing cases at the moment?
So for ongoing cases, under the CEPA Act as well as arbitration, the Form 7, the adjudication claim, adjudication response, and adjudication reply, and the statements of claim and arbitration just need to be copied to the AIAC. It doesn't need to actually be served. It doesn't say served on the director. So for those documents, as long as we are given a copy of it, then that is okay. In terms of whether or not the parties have already agreed to service by way of email, that's something you might want to check with the adjudicator to see if there can be an agreement, so that way you can still serve documents during the MCO. Or we've been seeing a lot of parties that are unable to get the documents from their clients, so they're having to ask for extensions of time. So it just really depends on the situation that you're in, but you're still able to serve all of the ongoing documents on the AIAC, and that's not an issue.
That's right. I think that is also a lot of practical issues or problems that the parties would be actually facing at the moment for ongoing cases as well. You know, I have also had two active adjudications at the moment, whereby the parties have actually proactively, even during the MCO period, asked for an extension of time. Of course, I have granted that for practical reasons. And not to affect, you know, the integrity of the proceedings as well. The constraints that the parties are facing at the moment would also be a good ground for such an extension. Now, that is for submission of documents. How about payment of deposits? As you know that, you know, there will be a period of time as ordered by either by the adjudicator or the arbitrator to make certain deposit payments. If anybody would wishes to make a payment, and how are they going to do it at this time? I understand that the banks are still open.
Mm-hmm. So right now, since the AIC's premises aren't open, you can't, typically you would be able to just send the check to us. However, since our offices are closed, we can't accept the physical checks. But you have two options. You can either deposit it with the bank. When you're depositing it with the bank, if it's over 10,000 ringgit, it needs to be submitted over the counter with the invoice attached. And if it's under 10,000 ringgit, you can put it through the machine. Otherwise, you can do an electronic bank transfer, and the invoice for each of the deposits will have the correct bank account and information for that, where you can effect the bank transfer for any of those deposits.
Yeah, also that means that after they have deposited the monies, they just need to send the bank-in slip back to the respective or relevant AIC personnel who is in charge of that matter. Correct, right? All right, yeah. And if they really want an electronic invoice, at this point in time, you can still request for AIC to issue those invoices as well. So the even though the office is not open, you are still in a position to issue invoices.
Yes.
Am I correct?
Yeah, so we can still issue invoices. If we need any of the invoices, we've had some where people needed the invoices amended. It might not have been addressed to the relevant department that makes the payment. Sometimes parties have specific things they need on the invoices. So we still are able to issue the invoices and also official receipts once the payment proof comes in and that we can clear the payment. So we've been still issuing invoices and official receipts following the payment. Thank you.
Oh, all right. Thank you, Chelsea. Hong Kit, do you have any further questions for Chelsea?
Yeah, sure. Hello, Chelsea. Okay,
Hello.
my first question is this. Can you tell us where are you now?
So I really wish I was on an island, you know, hiding away during this MCO, but like everyone else, I'm locked in my apartment in KL right now.
Yeah, because seeing the palm tree behind you, I thought you were on holiday. Okay,
no.
right. Okay, Chelsea, I have the AIAC announcement dated 17 March with me now. Apart from the encouragement to the adjudicators to exercise their discretion, there hasn't been too much information provided by AIAC to the adjudicators as to how to carry on and what are the options available for adjudicators whose decision deadlines are fast approaching or even due within the MCO period.
Yeah, so similar to how the parties can ask for extensions for their submissions, adjudicators also can ask for an extension under the SIPA. If there's the Form 13 has a template of how you can request an extension of time for decision from the parties. So we highly encourage that parties also are understanding to the adjudicators during this time and allow the extension to take place. Adjudicators have any issues with the parties, there might be an instance such as when you have a respondent responsive at all, but then you're likely only making decision on the adjudication claim, so you might be able to do that while working from home. But if there's any issues, they can ask for an extension from the parties. Thank you. And also they can ask for, from haven't already agreed, ask to service by way of email. So that way they can serve the adjudication decision on time and then follow up with the hard copies later once the MCO is lifted is another option as well.
Oh, I see. Okay, Chelsea, so under Section 38 of CPA Act, unless otherwise agreed by the parties, all three default modes of delivery require physical delivery to the parties' addresses. As most premises are now closed, if the parties have not agreed to adopt email as a mode of communication or mode of services, how will the MCO affect the delivery of the adjudication decision?
So during that time, the adjudicator, what an option they can do is, so under, I think Wai Loon's book also explains this a bit better, but in Malaysia, there is, US, we call it the mailbox rule. I think it's called the post rule here. But basically it means that if you send it by post, that's effectuating service. I'm not sure if it has to be when the post date needs to be, but you can, if the adjudicator has an issue where the parties aren't agreeing to an extension or aren't agreeing to service by way of email, they can still post out their decision and then provide the parties with the tracking reference number.
Right. So what if the adjudicator refuses to grant extension of time to serve adjudication claim, adjudication response, and the adjudication reply? What advice do you have for the parties?
So unfortunately, under the SIPA, there isn't a appeals recourse for that. I think one of the best ways when approaching extensions of time that would help encourage the adjudicators to permit it is if you first actually contact the opposing party, because if you come to the adjudicator with both sides agreeing on something, saying, look, you know, the respondent or the claimant, depending on which side you are, has already agreed to this extension of time, I think the adjudicator would be more likely to grant it rather than deny it, because if both parties have already agreed to the extension, it would be very unreasonable for the adjudicator to not permit that extension. So I think if an adjudicator permitting it, maybe contact the other party and see if they would be willing to say, look, we also agree because we will want a similar extension once it ends up being served. So I think one option is to try and work amicably on this with the other party. I understand sometimes in disputes, people are at each other, but I think during this time, everyone just needs to be understanding. And yeah, our advice is try to contact the other party because there is no appeals recourse under CIPA.
Chelsea, I have a very important question for you now. In the AIAC announcement dated 17 March, it only says that AIAC Secretariat will continue working from home. Other departments have not been mentioned at all. So is the finance and account department also working from home, and will adjudicators and arbitrators receive their fees during MCO?
So our finance department is working from home. Like I said, they're able to do the official receipts, do the invoices, any of that. However, for payments, our finance team actually needs to be in the physical office. So to effectuate any payments to the adjudicators or arbitrators, they actually have to, the way our finance department works, they need to cut the physical checks. So until our finance department is back in the office, we won't be able to send those checks out. So unfortunately, during this time, those payments have been, will not be able to be done until after the MCO is lifted. Thank you.
Sad news indeed. So it is a requirement under the statute that the appointment of arbitrators and adjudicators are to be made by the director of AIAC. As we know, Mr. Vinaya had recently passed away, sadly. AIAC is now left without a director. Can you share with us how AIAC is dealing with the appointment, and when can the parties expect to be able to submit their appointment requests?
Yes. For any new appointments that we have received, whether it be arbitration or adjudication, we've been notifying the parties that it can't be made until after the new director is appointed. So we've given the parties the option that we can either refund their payment or we can hold on to it until they submit their new fresh request once the director is appointed. So unfortunately, all appointments will have to be put on hold until the new director is appointed, then following which the parties can submit the request, although we do ask not to flood us too much with, I don't know, hoping about getting 100 appointment requests on the very first day the director is appointed. But once the new director is appointed, we will contact the parties that we've already been discussing appointments with and notify them that the director is appointed so they can send in their fresh Form 5 or arbitration appointment requests.
Similarly, if a decision by the director of AIAC is required, for instance, to determine the withdrawal cost, are there any other avenues for that to be decided?
So if the rules of either CIPA or our arbitration rules stipulate that the decision has to be made by the director, unfortunately, there is no other avenue for that decision to be made. So things like withdrawal clause, challenges to arbitrators, certain extensions of time on deposits for arbitration would need to go to the director. For extensions of time on deposits in adjudication, that's actually under the adjudicator's powers. So any extensions of times to pay those deposits directed to the adjudicator, not to the director of the AIAC. But for deposits in arbitration, any extensions of time will not be able to be decided until the new director is appointed.
Oh, I see. Apart from the proceedings, what about the AIAC's events which we miss going, such as the adjudication training and also the highly anticipated ADR Week 2020? Are those being affected?
So currently all of our upcoming events have either been postponed or put on hold. So the adjudication training, we will determine a new date following the lifting of the MCO and what the government decides in terms of other gatherings are still put on hold for a certain period of time. So that we'll have to just wait and see what happens with the current situation with the pandemic. For Asian ADR Week, what we have determined is that because it's very likely that people aren't going to be traveling as much towards the end of the year, and there's a lot of other events being postponed, we figured instead of trying to find a new date in 2020 to postpone it until next year. So our Asia ADR week will be in June 2021. It will be the same program that we had scheduled for this year. We're in the process of contacting all of the speakers to confirm that they're available for the 2021 dates that we are proposing. So we're looking at the week of June 17th. However, that will be determined once the director is appointed. We'll determine if those are going to be the exact dates in June, but it'll be June 2021. But we've also started, we have a webinar series that we've started to kind of bring some light and hopefully have something to do while we are all stuck at home. So we have our ADR online. You can go on our events page and see our upcoming webinars if you want to check out any of those.
I'm sure many will be disappointed with the postponement of the ADR week. But however, at this point of time, the battle with COVID is our first priority.
Yeah.
That's all from me. Wai Loon, yeah, anything from you to add?
Oh yeah, actually, you know about the postponement of the AI ADR weeks. I'm sure about the other trainings that had been lined up by AIAC before, which had already been postponed as well. Like even myself, you know, Chelsea, you know very well that I have also been invited to be involved in at least 2 events organized by the AIAC. One is actually the AIAC adjudication training program, which was initially scheduled in April, that was postponed, and also the AIADR week as well. Personally, I'm quite disappointed because we all were actually looking forward to these events to connect with the people on the ground and also our peers. You know, all in our minds is, you know, it's not only a continuing legal education platform, but also to enhance or enlarge our network in a way. And with this COVID-19 still being uncertain, AIC definitely will not be in a position, at least in the near future, to hold any physical events. But I understand that AIC is actually actively holding webinars as well, just like this L2 construction series, right? And how has it been doing? Is it very well received? And you have various topics lined up till the end of the year?
Not until the end of the year, not yet. we are going to especially considering the number of events that are being postponed even further out, we are going to continue the webinar series even after the MCO is lifted. So right now we're trying to have webinars pretty much daily, on every weekday during the MCO. So this past week we had one in insolvency and ADR. So how does insolvency of parties affect ADR proceedings, as well as can ADR be used for insolvency disputes? So that one was really well received. We had great attendance for that one. We also had one on domain name disputes. We have one next week. We have one focused on construction. We have another one focused on how both India and other Asian countries are receiving the COVID-19 within regard to their ADR proceedings. We have one on careers in arbitration, discussing how careers are being affected and how the hiring process is being affected during this time. And then we'll have another one on the changing tides in advocacy, discussing whether advocacy has been transformed and using these virtual hearings. So we have
so many programs are being lined up online. I'm sure that any audience would like to have a look about the programs which have already been lined up. They would be able to do so by clicking on the AIAC website. Am I correct? Yeah. All the information you want to find is there. So before we move on to other lighter questions, Chelsea, because we still have some time, about 10 minutes, I would like to address the issue that you raised during your answer session just now about the postal rule. Now, as you know, that Section 38 of CIPA, there are the first 3 modes of delivery or service of notices and documents under the Act are actually either posting or physical leaving of that documents or at the offices. Now, regard to the postal rule in Malaysia, I've just taken the liberty just now to check on the matter, and there is in fact a Supreme Court decision in Malaysia, which is Amanah Merchant Bank against Lim Tao Jun, whereby the Supreme Court judge in that case held that a notice was said to have been posted by registered post when the notice was correctly addressed, prepaid, and delivered to the post office and acknowledged for service by the post office. And that is the point of time when the notice is said to have been posted. Now, as to the effect of the delivery, when does it take place? The effective service delivery takes place in the ordinary course of the posting. Now, that would depend on where is the location of the party you wish to send to, and also ordinarily how much time would it take in the ordinary course of things, assuming that there's no intervening event that happens in between. Now, normally it would only take about 1 day from the date when you have successfully posted it at the post office. Now, these are actually the guidance that you can resort to in calculating the time for the purpose of an effective posting. Now, I'm going to ask you some personal questions, Chelsea. Now, as you know that in this very difficult time, a lot of people are actually looking as to cut costs, right? Of course, this is not the concern of AIAC. I just want to get some information. Without a director at the moment, are the salaries still being paid as usual to all the staff of AIAC?
Yes, everyone is still being paid.
I see. Okay. I also understand that the AIAC, a lot of the personnel are actually foreigners, like you, Chelsea, and you would like, you need the visa or perhaps a contract extension for you to stay in Malaysia. Currently, without a director, is that posing a lot of problems to those people whose contract is actually expiring or the visa expiring at the moment?
So
and what are they?
Yeah, currently none of our employees are having, luckily right now, there's no one that's having issues with the contract itself. I do know we have one employee that has a visa coming up, but from what I understand from the Malaysian government, if you have a visa, they're giving you some leeway to get an extension on that visa so you don't have to exit, because typically you have to exit the country, come back in for the renewal process and things like that, or transferring. So I know they're giving some leeway. So I know our HR department has been monitoring that situation and that there shouldn't be any issues with the visa, because I think the government would prefer that everyone stays in place rather than trying to figure it out. They're giving leeway in terms of the visas issues.
I see. Okay. Thank you, Chelsea, for sharing that very confidential information of private matters with us. Now, the next question is quite interesting. Does anyone in AIAC, including yourself, have any information as to who the next director would be?
So we do not. The AIAC is not, so under the host country agreement, it's the Malaysian government in consultation with ALCO that would determine the next director. I do know that the Malaysian government is currently working on it. However, we've been in contact, I know, with the Malaysian government, but they do have some quite pressing matters on their plate right now with the MCO and COVID-19 that take a precedence over the AIAC director, but I do know that it's on their list to do. We just don't know when it's going to happen. Hopefully things with COVID-19 start getting better, because once those get better, then I think everything can start going back to normal.
I see. All right. Now, Hong Kit, I think during our questions, these additional questions posed to Chelsea, Hong Kit has actually taken the time to look through the questions posed by the audience. Now, Hong Kit, have you gotten any questions from the audience that you would like to direct them to Chelsea?
Yes, Wai Loon, I have some questions posed to me. This question is a bit less interesting than the one you just asked. Instead of asking who is the new director, Chelsea, is there a timeline set for the appointment of a new director?
Under the host country agreement, I don't believe so, but I think you would have to, that I'm not sure, but I don't think there is a timeline prescribed in the host country agreement. I'm not sure.
So you won't know it's a matter of days, weeks, or months?
Yeah, unfortunately, we don't have a set time when, we don't know the exact date of when it's going to take place.
I see. The second question is this, how does AIAC deal with the cases where neither party make payment for security deposit? Meaning to say neither party is interested to pick up the decision.
So in those matters, really it's up to the adjudicator how they want to decide how they handle it. So typically the adjudicator has two different options. During the course of the proceedings, if the security deposits are not paid, assuming that this is a adjudication case, the adjudicator can actually basically suspend or terminate the proceedings based off of non-compliance. So it would be a non-compliance with the adjudicator's directions that they could end up suspending or terminating the proceedings, or they can issue the Form 14 towards the end and it's just one party not paying, and basically hold a lien on the decision until the payments are made. But the CEPA Act does not prescribe the AIAC or the director of the AIAC any powers to terminate or suspend the proceedings. That's solely within the discretion of the adjudicator, not in the discretion of the AIAC. For arbitration, it's also in the arbitrator's or the arbitral tribunal's power, but it has to be in consultation with the director if they want to terminate the proceedings. If before an arbitrator has been appointed, then the director of the AIAC could possibly terminate the proceedings if deposits haven't been made.
I see. Chelsea, just one more question. In the event only one party makes the security deposit, and this usually will be the claimant, the respondent refuses to make its part of payment, then the adjudicator will invite the claimant to make the payment for the respondent. So if the claimant also refuses to make the payment, can the adjudicator release the adjudication decision and take only half of the fee that he is entitled?
So it's within the adjudicator's discretion. Typically, I don't think I've seen an adjudicator release the decision if half of it is outstanding. Typically what they'll do is issue the Form 14 and hold it on lien. So typically what I've seen is that the adjudicators will hold it on lien until that is made, because if the claimant is the winning party, then they would be able to recover those costs from the respondent. So typically I haven't seen any times where an adjudicator would release the decision and only accept half of the payment. But technically under the CEPA, that is an option if the adjudicator so wishes, but that's not normally what we've seen in the course of proceedings.
But the adjudicator can do that. He can release the decision and take only half of the adjudication fee.
Correct.
Okay, Chelsea, I have also gotten a question. I think this question is a little bit controversial and it could be a matter of the past as well, or some may argue that this is still a live issue. Now, the thing is that the question posed is this: if the director's appointment was actually not agreed to by the ALCO, what would be the fact now, whether the losing party can still raise a challenge to the legitimacy of the appointment of the adjudicator and challenge the enforcement application of the decision. Now, I understand that there have been a case brought before this. It's called Mega Sasa. I think this issue was argued. Not sure whether it has been extensively dealt with. I understand the parties had taken the position at that point in time that there was no issue, that Mr. Vina was recognized as the acting director, and whatever duties that he exercised during the time will still be treated as valid. Now, since then, are you aware of any other challenges or similar challenges being brought against AIAC on this ground at the moment?
At the moment, no, because I think, so the Mega Sasa case made it pretty stated as well that actually the forum to determine the directorship was not the Malaysian courts, but actually if you look at the host country agreement, any dispute between ALCO and the government would need to be gone through arbitration actually, and a settlement or amicable settlement. And also in the case too, it did state that even if it was determined later on that he was not the director of the AIAC, ALCO did approve the acting director. And so therefore, it would mean that he was just continuing as acting director throughout his tenure with the AIAC. Therefore, there shouldn't be any challenges. I don't know of any other cases that have had any challenges of this come up. I know that I don't know in any other cases that have brought this up recently. In terms
Okay, I understand. Fair enough. So you're not aware of any other new cases on which raised jurisdictional challenge on similar ground, correct? Right. Now,
No.
the thing is that we have come to the end of the session because we have overrun by 5 minutes. I would really, both Hong Kit and I would like to convey our gratitude and thanks to Chelsea for taking the time to do this interview with us. I'm sure the audience, you have answered most of the questions, if not all, that the audience might have before this. And these are really, really pressing issues, and you have given a really good update and some suggestions. I'm sure the audience will adopt as well during this period of time. Now, do you have any concluding remark for the audience?
Just that I hope everyone is staying safe and making sure that they're both mentally and physically healthy during this time, and find some fun things to do like this. Can keep busy. And thanks for coming.
Yes, it's important to keep our physical body healthy and also mental part as well. So, well, I have actually got a question from the audience. It's a request, it's not a question, that perhaps we do another webinar on the issue of liquidated damages. Now, I think for the information of the audience who are here today, this is the 6th day, and we have had the programs lined up until the end of the MCO period already. So, well, we will keep this issue in mind, and if the MCO is to be extended, then very likely that we will include that topic as part of our webinar series. If not, then you have to wait for further information to see whether Hong Kit and I would like to continue with this effort, right, even after the MCO as well. Hong Kit, over to you.
Okay, right. So we thank you, our special guest today, Chelsea, for this informative interview. And thank you everyone for joining us. Before today, we never really had enough time to address a lot of questions from the audience. And therefore, we got quite a few complaints about this in our feedback forms. We hear you, and so we are having a Q&A only session on the 13th April. We will select pertinent questions left by our audience throughout the 14 sections and address them at the Q&A only session. So continue to post your question. Don't worry. Even if we don't address them immediately at the session, I repeat, we will have a special Q&A only session to address them. As you can see, tomorrow we will have Chong Wei joining us here to share with us on the topic of good practices in construction contractual documentation. So see you guys tomorrow and have a nice weekend.
Thank you very much. Thank
Bye.
you, Chelsea.
Thank you, Chelsea.
Thank you, everyone.
Thank you, Wai Loon. Thank you, everyone.
Bye-bye. Stay safe.
Bye.
And stay sane.
Stay sane.